To you both, and thank you very much for coming today to help us with our evidence session today. We're much appreciative of it. Before I start, if I can ask you to introduce yourself from my left, say who you are, and if you represent any organization, feel free to do so. If you want to make an opening statement, also feel free to do so. If not, after you introduce yourself, we'll get on with the questions. So, Mr. Orman, you're going to...
Thank you very much. My name's David Ormrod. I'm a professor at University College London. I'm also currently seconded to the Law Commission.
Okay.
And I'm Carol McCartney, Professor of Law and Criminal Justice at Northumbria University Law School, where I run a research centre on science and justice.
Okay. Thank you very much. Are you happy if we progress with the questions now?
I'm happy.
Yes.
Thank you. Well, if I might kick off, what we want to explore as a committee is what you think is the understanding of forensic science within the criminal justice system, amongst lawyers, judges, juries, etc., and how you think this could be improved, and what channels of communications are there or are needed between scientists, lawyers, and judiciary to bring about this improvement, and is the criminal justice system being equipped with robust, accurate, and transparent forensic science?
Thank you. Perhaps I can begin. I think the level of understanding is certainly improving. The Law Commission produced a report in 2011 with recommendations and indeed a draft bill. And at the heart of that was a concern that expert opinion evidence in criminal trials wasn't being properly understood. Advocates weren't exploring the vulnerabilities in the disciplines.
Sorry, I missed, when did you say that was?
That was 2011. And since then, the position has certainly improved. The Law Commission recommendations have been implemented in an innovative fashion in the criminal practice direction. So the bill wasn't taken forward, but the recommendations have found their way into the criminal practice direction. And that itself has then generated a lot of interest and a series of initiatives from various bodies. So there have been training guides published, for example, by the Inns of Court College of Advocacy and the Royal Statistical Society on the proper use of statistics in courts, not only in criminal justice. And the Royal Society itself has begun to produce a series of primers for the judiciary. They've begun work with DNA evidence and gait analysis as what they regard as an illustration of a hard science and something of a much more subjective nature. There's also been greater engagement in judicial college training, so I participated in some of those training sessions, and the Royal Society again has facilitated a pilot model seminar for judges sitting in the Crown Court on understanding probability and the law. And they all build upon the forensic science regulators' work, in particular on DNA and cognitive biases and so on. So I think the position is improving, but I don't want to overstate the position. There's clearly further room for improvement.
Yes, I think overall the picture is one of improvement. It has been getting better over the years. We have had criminal procedure rules, criminal practice direction, although the extent to which these are having an impact in the courts is fairly an unknown at the moment. It's difficult to establish to what degree they're having an impact without any sort of transparency or any mechanism for assessing that. It's difficult to know. One thing that is of particular concern, perhaps on top of what Professor Ormrod has stated, is that there's obviously a lot of recognition at senior levels of the judiciary. We have primers being written, the Royal Statistical Society involvement and so forth. I think one of my major concerns has been at the lower levels where most criminal justice actually goes on. So in police stations, duty solicitors, but hard-pressed lawyers who haven't had extensive training, who haven't been educated in this during their law degree. That's a big problem, continues to be a big problem, the complete lack of any kind of scientific or interdisciplinary education during a law degree. And then, of course, the magistrates. So we talk about the criminal practice directions and so forth, but when do they ever get mentioned in magistrates' courts? When does that ever come up? So, and that's something that will probably get raised again when we talk about streamlined forensic reporting, that at the luxury end of criminal justice, as it were, there probably is a lot of information and education and a lot going on in terms of understanding expert evidence, but how far that reaches down into your nuts and bolts everyday cases that are happening very quickly by very hard-pressed people who don't have the time for training and reading primers and don't come across it regularly, then I would say that was still very much a site of concern.
Baroness Morgan, then Lord Fox.
Follow up on both of those points actually, which and it was very helpful what both of you said actually. What suggestions have you got about how that the positive stuff that's happening can be disseminated more widely? Because it's fine if somebody's got an interest or they're aware of the primers or whatever, but even amongst what you described, Professor McCartney, as the luxury end, or the even amongst barristers practicing regularly, presumably they're not all aware of the primers, they're not all aware yet of the range of material that is available. How can that be done more speedily? How can it be spread more speedily through the system?
I would suggest that there is scope for a compulsory element to the newly qualified practitioner scheme. Everybody who's qualified as a barrister or a solicitor has to undertake continuing professional development, certainly in the first few years, in a rather intense way, and there's an opportunity there for a compulsory module, a compulsory element relating to forensic science.
Okay, thanks.
Fox.
Just trying to get a handle on what you think people don't understand, in a sense. So, because you've indicated a direction of travel, and we've had evidence from in two different areas. One saying that there is still further distance to travel, and in fact, and another witness saying, "Don't worry, it's understood now." So I think it's good that you've confirmed that there is distance to travel. How far what is it that people need to understand, maybe at the luxury end and the busy end? What is it that people don't get?
I think one of the things, the difficulty I have perhaps with primers is that, yes, you've got one on gait analysis, on DNA, and you could keep going, but you could almost keep going forever because there are so many varieties, because each case will probably throw up its own type of problems and questions that could be answered by an expert. So you can't have a primer for every scenario. So it's almost the fundamentals that you need people to be trained in, how to tell. And this is something I think the populace should be trained in.
So what are the fundamentals?
How do you discern fact from fiction? When has somebody extrapolated too far? When is a conclusion unsustained by the data that they have? If you look at wrongful convictions, which I spend a lot of time looking at, most of the time there wasn't a fundamental error with the forensic science, is that it's been lent on too heavily, or they've stretched it too far, or somebody's pushed them to say that the evidence demonstrates this when it really doesn't. It might demonstrate something lower, but it's just been pushed too far. And I think increasingly as well, if you're trying to abbreviate the process, so you're doing less testing, you're going into less detail, then the fundamentals have to be accurate and they have to be right, and everybody has to understand, if you're using a shorthand of 1 in a billion match for DNA, what is that predicated upon? Is that safe science? And does that translate in the same way of shoe prints? If you say that shoe print matches, well, do we have the scientific basis on which to say that? So for people cross-examining or examining, they have to understand not the intricacies of that scientific discipline, but is this person overreaching or going too far with that science? Can these conclusions be sustained?
Could I just follow up on that? The Law Commission's recommendations in 2011 sought to produce a generic list. We consulted extensively with all sorts of forensic scientists, from psychologists through to those experienced in handwriting and ballistics, to produce generic guidelines which the experts told us they would be happy to be asked about by an advocate, because the advocate would then be testing the potential validity, the reliability, the soundness of the opinion expressed, and they were condensed down to 8 or 9 individual factors, and those have now made their way into the criminal practice direction, and they echo some of the things that Professor McCartney just said. The extent and quality of the data that the expert's opinion is based upon, whether it relies on inferences, whether there's a margin of uncertainty, a known error rate, whether it's peer-reviewed, whether the material falls outside the expert's own field of expertise, how complete was the information on which the expert's opinion was based, where in a range of opinions this particular expert opinion's statement lies, and whether the experts followed established practice. So the idea was that the advocate with no knowledge of the particular discipline could, by deploying those questions, test the validity of a science of which they were previously unfamiliar, and still be able to expose the strengths and weaknesses of the individual opinion. They were sufficiently generic.
Lord Renfrew.
Thank you. To what extent are the differences between what forensic science provision is available in practice to the prosecution and to the defence?
Well, this has become slightly more problematic, of course, with the heavy restrictions on legal aid, because one of the problems you have if you're trying to defend a case, for a start, without getting onto streamlined forensic reporting, you might have very, very little information to go on. You might just know that there's DNA involved in this case. But in order to interrogate that and to get beyond just there's a DNA match in this case, you need to understand, well, what does that mean? What's the significance of it? And do I need somebody to give me? But if you can't demonstrate to the Legal Aid Commission that there's something challengeable there, that it needs to be investigated and so forth. So it's a chicken and egg situation. You have to have some expertise to be able to demonstrate that you need legal aid to go and get yourself a defence expert, but you can't get the legal aid. So which comes first? And if you're dealing with solicitors who are very pressed for time and they don't have the resources or the expertise to understand whether or not they need a defence expert, then it is very difficult for people to get defence expertise. And very often, all you will need in most cases is for a defence expert to just look at the prosecution's evidence and see, does this need challenging or is it sound? And that could be all that's sufficient. It doesn't need significant retesting or going back into laboratories or whatever. But even getting that now is becoming increasingly difficult.
That does sound like a serious asymmetric disadvantage for the defence, which Analytic Services International told us at a former meeting. Sounds quite an imbalance as you describe it.
And I think one of the difficulties has been the loss of expertise over the recent decade with the closure of the FSS and the privatisation, and that some forensic science disciplines simply aren't in demand enough, or they can't make enough money, they're not sexy enough that, they don't get called on all the time. And yet, so a lot of these specialisms have fallen by the wayside. So if you now get a case and it's got fibre analysis in it, then where are you going to get your defence expert from? There was only like a couple in the country to start with. So to get different opinions, you're looking to the same couple of experts.
You mentioned fibre analysis. What other areas of sort of
I know toxicology is a particular problem, but having just spoken to a few forensic scientists, things like paint analysis has fallen by the wayside, which was quite a big thing in collisions and so forth, and so paint analysis doesn't get used very often, likewise glass analysis. So a lot of these sort of niche things that would, may have been used in a big case ordinarily, now, they're seen as a bit obscure. We won't need that. We'll go for the DNA, we'll go for the easy stuff first, and only if we really need a bit of glass analysis, we'll resort to it. But it's very much seen as a last resort. It's like an added extra that, unless it's fundamental to a case, wouldn't be done now. And so a lot of our glass and paint analysts now will be retired. And, I'm sure retired people are still very busy, but it's very difficult.
Is justice suffering because there isn't sufficient glass analysis?
I think you'll find that it's undoubted we could come up against a case any day where glass analysis could be central to a case and we don't have the analysts available.
Hunt.
One of the questions is there a limit to the amount of money that can be spent by the prosecution compared with the defence? In the case I was involved in as a consultant, I mean, the government spent £1 million or some pounds in a big government laboratory, and other people had to do them in a lab or a kitchen or something, but they were able to do it. But I mean, can the police just carry on doing more and more? Is there some financial discussion as to how much can be provided? I mean,
Well,
that would seem to be very unfair.
I'm sure police budgets are under significant strain, and they would have serious limitations on their budgets for cases now, and they do work within strict budgetary constraints for forensic science. But I would imagine that getting money out of the Legal Aid Commission is significantly more difficult.
Can I just give an example of the way that actually the resource impacts as well on some of the prosecution evidence? There was a case decided in the Court of Appeal last year in which it was a conspiracy to supply drugs case, and unusually the incriminating material on the telephone wasn't demonstrably owned by the defendant. So the prosecution were required to demonstrate that the telephone was his, and they sought to do that by demonstrating that he was in the same location as this incriminating telephone, and they sought to do that by reliance on CCTV evidence and on cell site evidence. But despite the orders made by the trial judge in that case, they didn't deploy an expert to do that. They sought to rely on a police officer to explain the way that cell site analysis worked. The trial judge refused to admit that evidence. The prosecution appealed that ruling. The Court of Appeal upheld the trial judge's ruling, so effectively upholding the acquittal, because the police hadn't been in a position to use an expert to describe the detailed way in which cell site analysis operates in mobile phones.
So one of the points that struck me was that if an experiment or analysis of data is to be done, this isn't treated like a scientific experiment in which different people are looking at how the experiment and the data is analysed. They presumably display or give the conclusions, but there isn't a sort of analysis of why did you take this data or you take that data. I mean, I thought there was some beginnings of a discussion sometimes between the experts, modulated by the judge, and that's an efficient or just system. Is that coming more frequent?
I would have no idea.
I can't comment on whether it's more frequent. The criminal procedure rules certainly empower the judge to make those orders so that the experts can meet.
Because some of the other evidence we've had suggests that this combined approach of looking at the science is becoming more.
Yes, I think what's particularly valuable is if the experts can meet to identify those areas on which there is common ground and those in which there is dispute, so that the trial process becomes more focused and more efficient.
It sounds as if you agree with this, but Professor McCartney doesn't agree with that. Is that?
Oh, I do, entirely. I'm just unsure as to how often this actually happens in practice. And with the proviso that we're again talking about very much the luxury end of the criminal justice system, where conversations like this would go on and cases would be that big. I think in a lot of the cases, decisions made very early on would kind of preclude those conversations happening, because opportunities would be lost and the investigation would have already gone down one avenue, and so the idea that they reopen an investigation or look at doing more scientific testing later on, once it's reached those later stages, would strike me as quite unusual.
So my last question, is this comparative science approach, is this in the handbook now, that this is something that the lawyers should consider?
Well, the criminal procedure rules encourage the experts to meet so that they can identify common ground.
That's quite progress. How long has that been in operation?
That's been in the criminal procedure rules since at least 2015, but well before that, Lord Thomas.
Quite recently,
Lord Thomas, I was going to ask you, you've said a lot about the lower end of the criminal justice system. What do you mean by that? Do you mean not in the Crown Court?
Yes.
So in the magistrates' courts?
In magistrates' courts and police stations.
And in magistrates' courts, what is the evidence you have which shows that forensic science is much used in such cases? Or not used? What surveys have you done, or is it just supposition?
Well, it's just supposition from the evidence of barristers and solicitor advocates and people who work in the courts, and the way that streamlined forensic reporting is now being reported, that how that is
Streamlined
working.
forensic reporting is something different. What I was asking you about is in the magistrates' courts, where obviously offences are of much lower order. That's where your concern is, not the Crown Court.
I mean, I have a concern about the Crown Court as well, but I think that there's been significant improvements at that end, and that work has been done, and that there's very experienced advocates and judges working in those arenas.
Good, thank you.
Ms. Manningham-Bull.
Thank you. We started this session asking about whether there was enough knowledge on this subject among the judiciary, and you both had views on that, and also on the fact that training needed to be compulsory in this area. That was your view, Professor Ormerod. Can I sort of come at this question from a slightly different angle? Is there any way, when trials take place and science and forensic science is exposed and challenged, is there any way, any system for capturing the lessons from that for the next trial, on the science, not on the other things?
I'm not aware of any systemic process for that happening. I imagine that amongst advocates themselves or amongst the experts themselves, they would go back to their workplace perhaps and have a mechanism for sharing, well, this happened in this case, and perhaps there's some CPD goes on in professional organisations, but centrally there is no way of us.
Okay, a related question then. Would you have suggestions about how criminal trials conducted which would ensure that those participating, whether the jury or anybody else, would have a better understanding of the weight of the forensic evidence? You touched on this at the beginning, Professor McCartney, about it not being the actual specific bit of science, but how to look at it. Is there anything else either of you want to add to that answer?
I mean, I've done research for many years on the education, legal education. Obviously, I'm a legal educator, but and one of the things that has long concerned me is the narrowing of a discipline, and very often narrowing of specialisms in education from a very young age. So, I mean, I point out that I abandoned science, as it were, because I said, well, I don't like science, and so at the age of 16 I had nothing more to do with it. But that's very difficult then, if then you're then going to try and deal with forensic science as a lawyer later on. Like the people who come to my law school, very often they will not have studied any science for any number of years. And then, of course, to try and inject it into a law degree is very difficult because you haven't got the expertise there. You need to work across faculties and so forth. But I think there's a central place for teaching any student, not just law students, some of the basics of science and validity and robustness, and how can you tell fact from fiction and so forth. How do you deal with facts? How does evidence get gathered and so forth? Because we have to deal with that in our everyday lives. I mean, you know...
So where would you teach them that?
I mean,
you gave it up at 16, so did I.
Yeah. I mean, there have been some improvements. I know at post-16 there's like A-levels now in the public understanding of science, which so you can do about science rather than chemistry, biology, or physics and so forth. But I think it's very difficult, or I found it very difficult, and others like myself have found it very difficult to convince legal educators that we need to be teaching anything interdisciplinary.
Do you want to add to that, Professor?
Yes, if I could. I think I'm also unaware of any routine mechanism by which the information is captured. I think judges and lawyers could do this. There just needs to be a body with the responsibility for doing so, and it may be that the Science and Justice Forum, about which I'm not sure what the precise remit of that body is, but a body which has a collaborative membership with the judiciary, practitioners, academics, the forensic science community, policing, all represented, which can regularly and routinely review developments and lessons to be learned. I think that would be a very valuable thing, which can then, it would also avoid the sort of fragmented picture, which I think there's a risk of a fragmented picture developing when we have primers on certain topics being developed by the Royal Society. We have the Royal Statistical Society producing a different guide. We have the Forensic Science Regulator producing a different set of guidance, College of Policing and so on. Having, if I might be excused from using that expression, a more joined up approach with one body having the oversight of how all of that information is fed back to the different communities, that might be very valuable. I think in relation to juries, you asked about how we might understand whether jurors are understanding evidence. That's much more difficult because, of course, we have to be careful not to trespass into their deliberations. But my colleague at University College, Professor Cheryl Thomas, has conducted numerous studies now into the way that jurors deal with different items, different parts of trial evidence. So it is possible, by the use of very careful questionnaires, to ascertain whether jurors have properly understood the scientific evidence which has been adduced at trial.
With what result?
Well, that hasn't yet been conducted to my knowledge, but...
there has been research done in Australia and America, and it's not all positive.
Baz Young.
You mentioned briefly streamlined forensic reporting. Do you think it's a good thing or a bad thing? And can you answer that from both the prosecution side and from the defence side?
I think it was born from good intentions. I think one of the difficulties, the fundamental idea that, because one of the problems links to this last question about the feedback loop, what are we learning? Well, one of the problems is that we don't know what's effective and what isn't effective. So in one case you might spend £1 million. Was that necessary? We probably didn't need to spend that amount. A lot of what you could do if you have budgetary constraints is spend your money wisely and spend it to greatest effect. And so one of the issues around the streamlined forensic reporting was to perhaps cut down on wastage. So we have an awful lot of attrition in the criminal justice system. There are cases reported, some get investigated, some then just go nowhere. And a lot of these cases will have had forensic science involved in them. So it would be good to understand where are we wasting our resources, but then also not to have too much forensic science being done when it's unnecessary. And I think that was the basis for streamlined forensic reporting. Let's not spend thousands of pounds on unnecessary testing if the defence aren't going to challenge it or if it's undisputed. And if we can just do one DNA test and so forth and then just say we've got this DNA evidence, and then I might have issues with due process and safeguards and so forth, but if then there's no contesting and there's a guilty plea or whatever, then that was an efficient use of resources. The difficulty I think now with streamlined forensic reporting is it's being pushed too far down these efficiency lines in terms of we're going to do the testing very quickly, very cheaply, the minimum we can get away with. You get a computer printout that's very often been generated by an administrator who hasn't done any of the testing, with a standard paragraph that can tell you the very basics. And very often that is then used as we've done the forensic testing. And if there's no proper understanding that this was only very preliminary or very basic, then dispositive decisions are made on the basis of very, very basic testing. And even that's been misunderstood very often. So there's been examples given where DNA testing has proven, well, the defendant could not be excluded, and they've gone to trial on that basis. That's a very long way from this DNA is matched to this defendant and that this is uncontestable, that needs further interrogating. And so somebody in the process has to pick that up and say, oh, this is insufficient, we need more than this, and then apply for legal aid to get more testing done, or go back to the CPS and enforce that they get more testing done. So I think the difficulty we're finding with streamlined forensic reporting is it is being used as a shortcut, And if assurances are placed on it or too much weight can be placed on it, then that can be risky. You risk people making guilty pleas where they shouldn't be, and testing not being done. Just another example, a solicitor said to me recently he had an arson charge and he had a streamlined forensic report that said these chemicals were found. But he doesn't know if that means the arson charge is proved. He doesn't know anything about arson. He doesn't know anything about these chemicals. So then he has to argue to the Legal Aid Commission, I need more testing done to test these. But he didn't have the wherewithal. He needed an expert to tell him how to argue that he needed an expert. So he didn't challenge it. So they just find other ways of challenging things.
And who pays for the streamlined forensic reporting?
That's part of the police investigative process.
So the defence doesn't have to pay anything at all?
Not unless they're going to challenge it or do their own testing.
Okay. Professor Ormer,
I think, as Professor McCartney said, they're setting out from a different point of view. The rules that we've described, the criminal practice direction and so on, were all introduced to try to enhance the reliability. They were looking at the validity of the opinion and looking to the underpinnings of that opinion, whether it was sound. This is an initiative which is designed to expedite. It's an efficiency measure, and there's obviously going to be a tension there. So from the anecdotal evidence and from the legal literature that I've considered, the concerns are, I think, that they're presented, the SFR are presented in too stark a manner, and it's just too bold a statement. And unless the defence are willing to challenge, unless they are engaged, then there is the risk, as Professor McCartney mentioned. I spoke to a couple of defence practitioners who gave me anecdotal examples, echoing again what Professor McCartney said about a case in which they had mistaken bicarbonate of soda for Class A drugs, and if the defence solicitor hadn't been there on the ball and challenging that, there would have been obviously a serious risk of miscarriage. So it's the fact that they're presented in this stark way because they are pro forma, they're designed for a very different purpose. I think that is the risk.
Was that the fault of the process, the streamlined forensic process, that the mistake of the chemical, or was it a fault of poor science, which is not necessarily the same thing?
Quite that I don't know. I think what you can say is that where you have a pro forma model in which that conclusion is expressed in such stark terms.
But any pro forma that drives a mistake between bicarbonate of soda and a Class A drug is totally flawed and should be thrown out. So if that was the problem that caused that, then something needs to change. I mean, it seems to me to be more likely that it was bad science that caused that.
I think that the thing, and the witnesses later this afternoon will be far better qualified to talk about this, I think the difficulty comes because the police ask for certain tests to be done under the contract. So they pay however much money, please test this and tell us what it is. So the scientist, I'm imagining, has gone away and tested it and written up it's bicarbonate of soda. And so then you get a streamlined forensic report that's added to the prosecution papers, which somebody has to notice isn't actually inculpatory evidence because it's actually bicarbonate of soda, but it can get lost. And because it's such an abbreviated process, that the scientist has done his job, I've identified what the substance is. He probably isn't privy to, the fact that this was a Class A investigation, drugs, and so they've done their bit of the test and they've ticked the box and they get paid for it.
All right. Okay.
That is Morgan.
Can I ask a bit about whether you feel the needs of the criminal justice system, both prosecution and defence actually, are being met sufficiently? In particular, our understanding, I think, from previous witnesses, is a lot of forensic science testing is done in-house by police forces. And to what extent do you think there's a danger, therefore, that testing meets the needs early on of the investigating officers who are asking for that work to be done, but not necessarily meets the needs of the wider criminal justice system, whether that's CPS, judiciary, defence, or whatever?
I think the police are in a very difficult position because they're under lots of pressures to get cases investigated and time pressures and budgetary pressures and so forth. And I think from what I can gather, there has been now a fracturing of relationships where it become very much customer focused and price list focused around contracts with forensic providers, whereas there might have been the luxury of long conversations and coming up with strategies. So senior investigating officers would work with the forensic team and come up with a strategy for an investigation, and what do we really need, what would be ideal to do in this case, and so forth. There's not the time or the money or the connections for that to happen anymore. They have centralised submission offices, and there's an officer who will say, this is the testing you're allowed, it gets sent to the laboratory, and so forth. So I think there's been a significant loss there, and that's a significant loss to the criminal justice system more widely, because we aren't learning any lessons. Forensic scientists, I think there's been a great diminishment of their role, so a lot of their experience and so forth will fall by the wayside, because it will be here's a bit of powder, can you test it, and that's what they do. So there isn't that wealth of experience and knowledge gaining that they're learning from working on cases and strategies and looking at things in the round. It's very much a piecemeal testing process now. So I think the criminal justice system is shortchanged by that process. I don't think the police get a lot from it. I think we're seeing a great diminishment, like I say, in forensic science as an applied science in this country. We used to lead the world. I think no one would say that any longer, because we aren't investing in bigger projects and research and blue skies thinking and so forth. So the discipline isn't being pushed. And the criminal justice system will always lose out from that, because you don't know what's going to happen in the next case and what testing you might need, or what technology or what new innovative way of looking at it, because we're not pushing at those boundaries, and we're not being engaged in cases like that anymore.
Professor Omerod?
Well, I think there are probably others who are better placed than me to describe the way that's operating in the police sector.
Lord Keegan.
Chairman, thank you very much indeed. I want to just turn once again to the question of how robust the science base is for forensic science. What I think we heard in the previous evidence session was that where science itself is strong, so the forensic science that attaches to the broader science base is quite robust. But in areas that are developing or not frequently called upon, the research base that supports the forensic science is more limited. And what I'm very interested in is understanding what sense you make of that, and how confident you believe the criminal justice system can be with regard to the research base behind forensic science generally and specific areas. And secondly, in terms of identifying what research needs to be done, who is responsible for that? Where is the drive for more research in this area? How are those research needs articulated, and to whom are those research needs put so they might be addressed?
I'm happy to start. I mean, I think obviously you're looking for research now from two different sectors, so university, public sector, and the private sector, actual the forensic science providers. Now, forensic science providers understandably have to have a return on their investment, that they have to make money, so, and they are competing on price, so for them to then invest money in forensic science research which hasn't got a guaranteed return on it is going to be difficult for them to justify that, because they're trying to make money and struggling to do so out of forensic science provision to the police on casework. So then for them to provide blue skies thinking, invest in research and development and so forth, I think it's difficult for us to expect them to do that at the prices they're charging now, and for them, unless that they can see that there will be a new product or a design or something that they will then be able to make a return on their investment, and that's not really how private industry works, to my understanding. So then we would turn then to the universities and the public sector to be perhaps filling that gap and undertaking more forensic science research. But again, we come back to funding, is that it's difficult. Funding in universities is a very highly competitive area, And sometimes there's a reluctance if it is a very applied piece of research you're trying to do, it doesn't attract Research Council funding. And there's a difficulty with universities getting forensic science research funded. And of course the difficulty with that is if you aren't getting the research funded, then you can't provide doctoral places for students. So we end up not getting postgraduates in forensic science. So then you end up in a vicious cycle of, well, who's even going to undertake this research when we haven't actually got any postgraduate students in forensic science because we're not running programs for forensic science students. So then we end up with forensic science academics who aren't research focused or are not getting the time and the research and the PhDs and so forth to do that research.
Can I add to that? So in terms of the strengths of the opinion, where the science underpinning the opinion is sound, but the particular expert offering an opinion in a particular case is stretching the boundaries of that, which is offering an opportunity to the criminal justice system. We want to maximise the development of science in the forensic context. The criminal practice direction, those 8 factors that I identified earlier, should enable a good advocate to test the opinion, because the expert shouldn't be expressing an opinion in such concrete terms, in such explicit terms, that can't be substantiated by the underpinning science. So the guidelines, the practice directions, if applied properly, should tailor the expert's reports to an appropriate, moderated expression of an opinion that can be based on the science. And I think this is a concern that we really need to tackle, because we will see further sub-disciplines developing. I came across a case recently where I think there were more than a dozen different sub-disciplines of paediatrics involved in a shaken baby case. So no longer enough to say, well, this person's a paediatrician and therefore an expert. The sub-disciplines cause them to give opinions on ever more refined topics, and obviously that creates a greater burden on the advocates then to be aware of how strongly that opinion could be expressed by that person, and possibly an additional burden on the judge to ensure that the expert doesn't stray beyond his or her field of true expertise. And in terms of where are the research questions coming from? Well, again, I come back to this question: what is the Science and Justice Forum going to be working on? Is there a possibility for the Science and Justice Forum, if it's to operate as a collaborative board in the way that I described, with the relevant parties, the relevant players from the criminal justice system involved, perhaps they can anticipate, that board could anticipate where those gaps are, and no doubt if a research funding bid by a university was supported by the Science and Justice Forum, the National Science and Justice Forum, it will be likely to meet with success.
Can I, Lord Chairman, come back? Did the Forensic Science Service do a lot of research in terms of its methodology and its techniques when it existed?
Yes.
And it had a research department and so on?
Yes.
Fine.
They were world leading, and I've seen tables where the Forensic Science Service themselves published more articles than the rest of the country put together. They were very, very prolific.
And so, since their demise, the research output, therefore, has diminished considerably?
Yes.
You make the point about research. I mean, so much research and development is actually done in the private sector, in the pharmaceutical industry, in many science industries. The vast bulk of research and development is done actually by the private sector, not by the state. But you're saying that isn't the culture in those companies which are undertaking forensic science now?
Well, I think you'll find, like, your people from the forensic science providers will be able to tell you in more detail, but from the evidence that I've seen and from working in this area, it is very difficult because of the budgetary constraints to then invest in not only all the accreditation processes that they have to go through, but the process where they are competing so strongly on price in this country and turnaround times and so forth. Then I think a lot of them will admit that they have struggled to invest heavily in research and development.
Lord Mayor and then Lord Hunt.
Just ask
terribly sorry, tiny question. Where I've just googled, where is the Science and Justice Forum? When you Google it, where is it located, and how does anybody know about it? Because every time it was the same actually when the primers were first mentioned. I thought, well, I'll look those up. They're not available to anybody when you just look. So where is an interested consumer, in a sense, an interesting citizen who may sit on a jury at some point? How on earth does anybody know about any of these things?
Well, I hope a jury wouldn't, but be
Perhaps they should.
The primers are available on the Royal Society website, as far as I know.
Right.
In terms of the Science and Justice Forum, all that I know about that is that it's a Home Office-led initiative, and I don't know...
yeah, it's not on their website. It's on the Home Office website.
Yeah, all I know is that it was a group that were constituted in order to write the strategy, and I think they have just carried on.
Lord Mayor and then Lord Hunt.
Just following up from the question of Lord Kekar, in the context of gaps in research, and I think what my question is about is principally what universities might do, because I think you've explained that providers don't really do much research now because of the commercial pressures. But in terms of what universities might wish to do, am I right in understanding that the principal gaps are not so much in new techniques, but more in methods of interpretation, data interrogation, the sort of scientific evidence base for the validity of forensic science? Is that right?
Yes, I mean, a lot of the criticism of forensic science that's come from the US has been around that it's the underlying statistics and the basis of how people can interpret data and run experiments when the data just does not exist. So, and we have had cases where that has been highlighted in the courts, where opinions can be expressed about something, but actually the evidence base for it is so slim that it's very risky, shall we say, to rely heavily on that. And so a lot of the push in the US has been about these underlying validity testing. So just testing how reliable is the technique, and things like that's mentioned about margins of uncertainty, error rates and so forth. These are critical to understanding how robust is the science, how valid is this test in this scenario, when we don't have that testing hasn't been done for us to be able to express an opinion about how robust this is, or is there an error rate, or what variables could mean that this test didn't work in this situation. So DNA is obviously the outlier here because it has undergone a lot of testing, but I think that even DNA itself is pushed at boundary zone, and we haven't done all the testing that's required to confidently say this wasn't a transference, that this wasn't accidental contamination, that when there's 3 contributors to this profile, we know that we can isolate that's the major contributor. So we're pushing the DNA envelope even to places where it's now scientifically on shaky ground. So lots more underlying testing has to go on before we understand how often is DNA transferred, how long does it persist in the environment before we can't detect it any longer, and so forth. And DNA is one of the ones that's held up as being the most valid science. So there's an awful lot to be done for other sciences that haven't got that pedigree.
Sorry, Chairman, can I just clarify? So it isn't so much advances in new techniques that you're focusing
it's
on?
understanding the robustness and the validity of the techniques we're already using.
Yeah. Okay, thank you.
Can I just ask whether the insurance industry plays a part in this? Because you can imagine helping the detection of people who may be doing insurance crime, and the insurance industry has a lot of money. And a more orderly world would be helpful to the insurance industry. Therefore, they are very rich. You're talking about a situation of great shortage of money. Why aren't they helping?
I think it's a very interesting point. I couldn't answer for a minute if the insurance world are involved. But one thing that I've known for years, and I'm currently writing about, is that forensic science has so much to contribute to the criminal justice process, but also wider in understanding how do people die in accidents, how do we detect when people, how do we predict this person is going to be violent and so forth. There's a wealth of knowledge and understanding that could be tapped into.
But you have an insurance company, X or Y, professor of forensic science or something. I mean,
and I think another significant thing is to think about the costs of not doing forensic science properly. So we talk about wrongful convictions, but forensic science could saves us millions of pounds in preventing wrongful convictions, in ensuring that we don't arrest the wrong people, investigate the wrong instances. So a crime has occurred, it wasn't a death by natural causes, and also overturning wrongful convictions. So the Criminal Cases Review Commission need good forensic science too. So there's a massive saving to be made if we utilise forensic science
Chairman,
more.
maybe we could think about that.
Sorry?
Maybe we could think about having somebody from the insurance industry give witness.
Questions here, Lord Fox.
Yeah, turning to digital forensics, when we were talking with the Met, it's clear that they're being inundated by literally terabytes of data for individual cases. So what's being done and what needs to be done in order to deal with the current level of digital forensics that is appearing? Are we, and this isn't the question I asked, but is the criminal system learning from the civil system, where the presentation of documentation in large quantities has often been a character of that area? Are they applying the same techniques or some of the same techniques in order to sift and sort information correctly? And really, what skills are there the right skills in the right place within the civil justice system, within the criminal justice system, in order to handle what is clearly going to get more and more as our ability to store stuff increases?
I think there's a lot more that can be done here. So I think this is where we potentially are lagging behind in the criminal justice system. I spoke recently...
The civil justice system?
In the criminal justice...
Yeah.
Yes, lagging, quite. So the example that I used when I was speaking recently at the Criminal Cases Review Commission annual conference was to compare a street robbery, a simple street robbery. 20 years ago, there may have been the complainant, the defendant, an eyewitness, a handful of others who might have been able to contribute some small evidence, some scientific evidence. Now the potential is for that to be the evidence of those witnesses coupled with their mobile phone evidence, identifying where they were at particular times, the messages from the complainants and defendants' mobile phones, the dash cam footage from the vehicles that are going by in the public and private sector, the CCTV evidence, the fitness armband Fitbit wearing defendant who can demonstrate that his heart rate wasn't escalated at the time of the robbery, and so on. And the risk is that the investigators and then subsequently the trial drown in the data. There was a case recently where 53 terabytes of data were seized in a trading standards case, not a high-end serious fraud office prosecution, but a trading standards case. 53 terabytes of data. How that is then going to be processed by investigators and then dealt with in terms of disclosure and so on. So although it offers huge opportunities for the criminal justice system, because all of that material, all of that information or intelligence could be used to produce very sound evidence, the mechanism from getting it from raw data in that enormity into something that's capable of being digested in a criminal trial is quite an undertaking.
So I think we understand the problem, and you've just illustrated it. So what's the solution?
Well, I know that the Serious Fraud Office, for example, have recently been able to use, in one case at least, some artificial intelligence, for example, in assisting with the sifting of, I think...
Sorry, who used that?
The Serious Fraud Office.
Yeah.
In, I think, the sifting of some 30 million documents. But that's, again, as what Professor McCartney would describe at the luxury end. It really is the luxury end of the process. I'm describing...
Well, why is it the luxury end? Because once you've got AI, why can't it be applied at the mobile phone at the budget end as well?
Well, it depends how confident you are about what the AI is looking for. So in a case where you're able to be very confident and you have the compliance of the defendant, which is, I think, the scenario they were dealing with because it was a deferred prosecution agreement, they were able to then calibrate the AI so that it had zero risk of error. It was adopting a position most generous to the defendant in every case. Once you move away from something as heavily resourced as that, and you're talking about a street robbery that will be dealt with in the Crown Court on a routine basis, then I doubt that the resource would be available, certainly currently, to start thinking about using artificial intelligence to be able to sift those sorts of cases.
So you're using people instead, which is a resource which is costing a lot of money.
Huge amounts. If you're 53 terabytes of data is 200 million documents.
So comparatively cost-wise, to people sifting through terabytes of data versus an AI system which has an expert using it, what's the balance of cost?
Well, I don't know precisely what the balance of cost would be, but of course it's a slightly more nuanced position because the AI has to know what it's looking for. It has to be programmed in a way that doesn't itself contain biases. You then open up a different set of questions about
but the police have their own biases when you're looking for humans. Humans are not without bias when they're looking through the data in the first place, and in fact a non-systematic bias is harder to detect than a systematic bias in an automatic system.
I don't think we're disagreeing in that the opportunities that artificial intelligence and other digital technology will offer to the criminal justice system are significant, but they also pose threats, they pose challenges.
And then Lord Valence.
In the example that you gave of a fairly simple, straightforward case now becoming data heavy because of Fitbits and dash cams and stuff like that, does streamlined forensic reporting put a framework around that and say this is the seriousness of the incident and this is therefore the degree of digging that legitimately would be undertaken, or does it not really approach that kind of weighing up?
I'm not sure it is in the sense that the cases are all so very different. So a robbery would be a serious case. It's dealt with in the Crown Court. It can only be dealt with in the Crown Court. It carries a very heavy sentence, so it shouldn't be seen as a minimalist case, a very low-level case by any means. And by the time you've got to the production of reports on the evidence, you've already had to sift through the tens of thousands of messages, the hours of dash cam evidence and so on. So the cost has already been incurred.
But presumably decisions are made about relative proportion of investigation. So somebody somewhere is making them implicitly, if not explicitly.
Well, that's when you have to interrogate what happens at the police station level, and the submission is when they're looking at, anecdotally again, we're told that in a lot of cases, suspects or defendants themselves have said, here's my phone, this will show you that I haven't done it or whatever, but the police have decided for sometimes reasons about privacy and data protection, because there's some confusion around that, because if other third parties have got their data on this person's phone, then the police shouldn't be revealing that. So it's a very difficult area to understand legally anyway, but then just in a resource point of view, then the police might decide, well, no, we haven't got the resources, or they'll do preliminary testing and say we didn't find anything, and then of course subsequently the defence will then find evidence. But you're leaving a lot to chance there that a defence expert has got the time, or a defence. Some of the cases we've seen recently have been barristers poring over paperwork at 3 a.m. and finding, hang on, there's all these messages that prove my defendant's case. And so that's a very, very risky, and increasingly we're getting people saying that, that I had evidence and it wasn't found, and they said that they searched my phone but they didn't find it.
The House of Commons Justice Committee earlier this year concluded that more work could be done on this, and they encouraged the Home Office to produce a comprehensive strategy, I think was the expression that was used, to ensure that all of the forces were operating in the same way.
Lord Valence and then Lord Thomas.
Yes, just to explain to me a little further. The digital stuff, coming back to the digital pre-artificial intelligence, because that's the way down the stream a bit. This is largely a volume problem, is it? That what you're looking for are needles in massive digital haystacks. Is that about it?
I think there's a complexity and a volume issue as well in terms of how different systems operate, because obviously every phone operates differently, every company has its own so it's understanding how to get the data as well from the, there's cloud storage, and of course there's, commercial interest in not making that available to everybody. So, and then how do you validate the process that the expert used to get the data when they've just invented it themselves to hack into this phone?
Okay. I endorse that. The problems of jurisdiction here are not insignificant. The material might all be stored outside of this jurisdiction if it's all held on the cloud. Yeah. And there's also the difficulty in continuity of the evidence, because, of course, the dash cam evidence from the public service vehicle going by may well not have been revealed to police for some time. So there'll be challenges based on that.
Now, I know this isn't your specialist area, but at the moment, is this provided for by competing private sector forensic science providers, or is it a state provision?
I think there's a mixture of both. I think primarily prosecution would be the state sector, and then defence would be private.
But I think it may be that the prosecution also used private to some extent. Just as an illustration of the problem, there's a case recently in which the defendant was found to be in possession of 2 mobile phones. He was suspected of being involved in drug supply, and one of those phones was encrypted with a very expensive system for encryption, which 2 experts, both the first prosecution expert and the first defence expert, were unable to decrypt, and a third prosecution expert managed to do so. And the challenge was made to reveal the methodology by which he had done so, given that the other 2 hadn't been able to do so. And the trial judge and subsequently the Court of Appeal upheld the withholding. They upheld the decision of the trial judge for that not to be revealed, because it would reveal the methodology by which this decryption could occur. So it raises a number of different issues beyond volume. It takes us into a whole range of other issues.
Lord Thomas.
The police are under an obligation, obviously, to disclose anything that assists the defence or undermines the prosecution case. And for many years, the civil justice system has used search instruments to search huge documentary discovery. Otherwise, the system would have ground to a halt. Do you know, is it just a lack of money that the police haven't actually used what is commonplace in the civil justice system? Do you know the answer to that? Or not invented here?
I don't know. I think that might be regarded by some as what's usually described as allowing the keys to the warehouse, because
it's agree on search words and searching against what's contained in large volumes of documents. No, it's not the backpackers' passport to money. It's do you know why the police haven't done this?
You may not know, in which case you don't.
The answer is, if you don't know, don't know. That's all.
Okay, Lord Valence.
Final question, the catch-all, one for each of you. If you had the opportunity to make one recommendation, or have us make one recommendation, which would really make a difference in terms of the quality of forensic science and its impact in the criminal justice system, what would it be?
If I can go first, I think I would like to see the Science and Justice Forum or some board created which has this collaborative service. It operates as the hub in the way that something like the Police and Criminal Evidence Act board operates, to review periodically the findings, the experiences of those from across the criminal justice process, and here we would involve forensic science providers as well, so that they can look retrospectively on what lessons can be learned from cases, and they can look forward to which areas of science may need to be developed, which areas of training may need to be developed, and to ensure that all of that is done in a constructive, joined-up way.
A holistic forum. Yeah. Professor McCartney.
I think as well, I mean, investment's obviously the major thing that we need, an investment across the board in terms of education as well as forensic science provision and so forth. But to echo really Professor Ormond's point about kind of moving away from this disjointed system that we have now, and one of the things that we need is more understanding of what's going on, actually, because at the moment it's very difficult to pinpoint, well, there's the problem, we can plug this gap and we can plug that gap, because we don't really understand what's happening. Everything's very opaque. We don't have feedback loops, so there is no way of learning, well, how are the criminal practice directions working in the courts? I don't know. How do we find that out? How are the contracts working with the providers? Well, we don't know. And so it's very difficult, because some people must know how things are working and what's not working and whatever. And beyond yourselves getting people together to do an inquiry, it's very difficult for us to see the picture and to then learn and see how might we move forward in a far more effective manner than we are now. I mean, one of the things is just understanding what's working well, let's focus on that, and what isn't working quite so well, that we could perhaps stop spending or wasting resources on other things that aren't quite as effective. So understanding where things are effective and working well, I think, is key to then pushing us forward into the future.
Thank you.
Professor McCartney and Professor Ormerod, thank you both very much indeed for coming this afternoon. We appreciate it. And we'll stop the broadcast for a couple of minutes.
The proceeding is currently suspended. 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 The proceeding is currently suspended.
Again.